I'm just letting them know when to cue me so I know when we're live. All right, welcome back to another edition of Cannabis to Canada with Jason Wilcox. We are live streaming this interview. We are bringing it to you no other way, fiber optics. Mr. John W. Conroy QC, welcome back to the show.
Thank you, Jason.
Tremendous job you've been doing in court. Phenomenal work. Maybe we can just start off with just a little brush up on court so far, how you feel we're doing from both sides. I know that we can't speak to a lot of things, but what you feel comfortable speaking to, because people are definitely wondering, has the government proved fire, mold, and organized crime?
Well, you know, there's been a lot of evidence. We're now into our third week. And so the first week was mostly taken up with our plaintiff witnesses telling their stories and how they're impacted by everything, and followed by some of our experts in relation to not only the class of people, the demographics of the medically approved patients, but also information on extracts and that sort of thing from Dr. Pate, as well as Remo Colasanti, and the different equipment and so on that's available in order to be able to do these things safely. And to present, of course, the contrast with what happens with natural health care products under the Food and Drug Act. So Professor Baumann, who the government chose not to cross-examine, it's an odd procedure, this simplified action, because the public doesn't get to hear, and the people in the court don't get to hear all of the evidence, because they're filed in affidavits. And so you only hear, with the experts, a bit of a summary followed by cross-examination, but with all of the fact witnesses, you don't hear the whole story. You only hear the cross-examination and a bit of redirect. So there is, for example, Professor Baumann's affidavit, which is there, which attaches the Richter's catalog, which shows you just thousands of different herbs and plants that are for sale through Richter's, that have a red cross for some of them, which shows they're held out to be of medicinal value, or aloe vera, hundreds of different types of things. They show a knife and fork if it's edible, or a skull and crossbones if it's poisonous, various recommendations. So it illustrates the scheme of what you can do with plants and herbs that you're using as medicine if they're not a controlled drug, and that you can grow it indoors, outdoors, various limitations and lack of limitations. You don't have to register with Health Canada, these sorts of things. And how you can obviously do that with your food, and you don't have to put it through all of these processes in terms of mold and so on and so forth that they go on about in terms of the dangers and so on.
Well, this is something we discussed back in 2012. All the exotic herb gardens and exotic plant gardens, where people just grow in their basement and they grow different plants and do exactly that. They're not under the same scrutiny as cannabis growers.
Well, this is it, and you have to make this distinction between doing something that you're preparing to sell to the public as opposed to something you're just doing for yourself. So we say that if you're doing it for yourself, it's a matter of common sense, particularly if you're a medically approved patient, that you don't want to do anything to harm yourself, so you're going to take adequate precautions, just as you would if you were growing your own food. You're going to wash it properly or whatever before you eat it, or take it to the farmer's market or whatever. So, that's a natural thing. Because part of their argument is, you need to have, and it's not just the defendants in this case, in the U.S. and other places, they say, if it's going to be medicine, it has to meet all these standards and so on and so forth. You can't have people producing their own medicine. Well, we do when it comes to natural health care products, and we have them also for sale. So you have to look at that as the first sort of thing if it wasn't a controlled drug. And we know from the natural health care product regulations that plant medicine would naturally fall within their definitions, but if it's in the Controlled Drugs and Substances Act, like cannabis, it's expressly taken out, as is tobacco. Okay. And as you may have heard, one thing of interest to all of us was that you can actually grow 15 kilograms of tobacco for yourself.
Yes,
and,
to our online viewers, you can legally grow 15 kilograms of tobacco at your place, but they're trying to ban us from growing
for yourself
cannabis.
and anybody over the age of 18 years, as long as you grow it on that property. It's an exception in the Excise Act under the tobacco section.
I always thought it was illegal because I know it's a lot to cure your own tobacco. Well, it's a lot of work, but
and it's used for medicinal purposes in various countries, depending on how it's grown and these sorts of things. So it's an interesting analogy. So you sort of, we say, look at that to start off with. But then bear in mind, it is a controlled drug. And that's the sort of big distinction in terms of the situation. So the law that 2013 in the Ontario Court of Appeal and other cases that the government has to create a viable exemption. And so that's what the court's going to have to decide at the end of the day. Is this a viable exemption to the Controlled Drugs and Substances Act that provides reasonable access to the patients so that they're not put in a position where they have to choose on the one hand between their liberty by doing something illegal and on the other hand their health by foregoing their medicine. And the government has said we're not relitigating that, we're not re-arguing that. So that's your basic framework.
So that's basically Parker. We can go back 13 years to Parker and say that's
the basis of it, and that's carried forward. And I mean, it's the charter that's the fundamental thing. In Canada since 1982, we've lived in a constitutional democracy, and we have a specific remedy clause if your constitutional rights are violated. And the courts are the independent arbiters to determine whether or not your rights have been violated. And the government has, so for your audience, Section 7 is the key, broadest right to life, liberty, and the security of your person, and the right not to have those deprived in a manner that's inconsistent with something called the principles of fundamental justice, which here involve arbitrariness, overbreadth, going too far, and doing something that causes grossly disproportionate effects. So the Section 7 issue is the first issue that the court has to grapple with and decide whether or not they accept our submissions that, based on the evidence, the scheme, the exemption scheme that the government has come up with doesn't cover all medically approved patients and does impact the Section 7 rights of some of them. And so if we're successful in convincing Justice Phelan of that, the onus then shifts under the Charter to he or who asserts a limitation on those rights. And so Section 1 of the Charter puts the onus essentially on government to demonstrably justify any reasonable limits, and those reasonable limits have to be prescribed by law, so they have to be in a law, and they have to demonstrably justify those limits in a free and democratic society. So we say the evidence that you've heard after the first week, I mean, we had a bit in our evidence in the first week from Remo Colasanti and Dr. Pate in terms of dealing with mold and fire and electrical to some extent, because Mr. Colasanti gave us the evidence of how you can do things in a bloom box that's the engineered solution in a small space without impacting your neighbors, all the way up to a specially constructed room with air conditioners and so on. And with the big thing being to try and not have any impact on your neighbors whatsoever, not pose a risk to them, have adequate security, et cetera, and most importantly, no smell.
Like you would if you did any renovation in your house. This is what I gathered. If you did proper renovations like anything else, the fire risks are basically the same. In fact, Mr. Garris, from what I heard anyway, this is what I heard him say, is that he issued 400 tickets, I'm going off the top of my head here, red tickets, to medical patients, and then he believed all 400 came into compliance with the Surrey fire codes.
Well, the evidence was to that effect. I mean, what we drove from his evidence was that, notwithstanding the risks that he identified, many of which we don't disagree with, there's things that you automatically do or naturally do or can do cheaply to address the risks. As you say, it can happen with anything, and that's why, industry exists in order to enable people to do that. The only distinction, again, is there's no illicit market for many of these other things, and that's brings you back to the controlled drug thing. So the security thing and the assertion that this is so valuable that people want to rip people off in order to get it, and so on and so forth, which has been the case. I think it's pretty common knowledge, certainly amongst, I'm sure, your audience, that that's changed with Washington State and Colorado legalizing, and Alaska and Oregon and a number of other states.
I was going to lure to that. Now, there's no fire, there's no mold, there's no organized crime other than people bringing stuff in over the state lines because there's not enough supply in a place like Colorado where growing 6 plants and 12 plants per dwelling is legal.
Yeah.
Yet here in Canada, we're looking at this completely, again, out of 40,000 patients, 36,000 plus decided to grow or have somebody grow it for them.
Yeah.
I don't understand I never have. This is part of the reason we're here now and doing this case. And again, the premise, my understanding is the right to autonomy, and correct me if I'm wrong, the international right to autonomy to put into our body that which will medically help us, as long as we're not hurting ourselves or somebody else in the general public. If the government fails to substantiate fire, mold, and organized crime or public safety, if you have it, I don't see how they're able to actually strip me of that Section 7 right to autonomy that, in essence, Parker established.
Well, we don't frame it as a right to autonomy. In the earlier case that I referred to, Mama Levine and Caine, the Supreme Court of Canada made it clear that there's no lifestyle right to your lifestyle. But they also made the distinction between recreational lifestyle preferences and medical use. And so the Parker cases, and those that follow, make the medical issue clear, that it is about the security of your person. It is about taking something for medical purposes. And so I think we are past that now, and it's into the issue of, well, does that mean that you can grow it for yourself or have a caregiver grow it for you? And that's the issue for the court that, again, I say the difficulty is where do you draw the line between what's considered under Section 7 of the Charter as showing that your rights are being affected inconsistently with principles of fundamental justice, unfairly, improperly, and so on, arbitrarily. And so that's the first decision he has to make. And then the onus shifts to government, and we will argue, and we say, and have already submitted, that that's where any of this fire, mold, and public safety stuff comes in.
Yep.
It's to limit that right. And so we will argue that, in the absence of any statistics from Health Canada, which was conceded by the witnesses, the evidence of Constable Holmquist and Fire Chief Garris was the government evidence with respect to most of that. Once they filed those reports, again because of this type of procedure, we then got a number of what are called rebuttal experts to rebut their evidence. And so again, the public and those interested haven't heard what all of that evidence is. So you've heard from Mr. Garris, we've heard from Mr. Holmquist, we heard before that from the Health Canada officials, including Janine Richard. And so that's the government's picture that they have presented. And they're now, without exception, there's Dr. Grutendorst, the economist, yet to come, and for us there's Eric Nash to come as an expert and a fact witness. The other witnesses over the next few days are law experts on the U.S. law and Israel tomorrow, and then the next day is the Netherlands, followed by Dr. Grutendorst and then Eric Nash. So that's what's to come. So it's mostly international with a little bit of, but again, remember, there's all kinds of other rebuttal experts that we filed that they chose not to cross-examine. And two examples are Jason Shute, the mold man from Abbotsford, who deals with mold. He's remediated grow operations and other houses with mold problems. And in response to their expert necessity to cross-examine him, we thought we need to cross-examine Dr. Miller, who says, if you have a lot of plants in a house, you're going to get a lot of mold. Everybody knows that. The question is, how do you deal with it? And Jason Shute, a couple $100, his evidence is with a thermostat and so on, a dehumidifier, you can control it. So similarly, was an electrical inspector or electrician contractor and so on. His material showed what they all have to do in the Safety Standards Act and all these sorts of things. And so his evidence, which you didn't hear because it wasn't cross-examined, was to the effect that, look, this can all be done safely. We don't want to go back to what it was before, because that'll drive it back underground. We've come from an underground situation, which the policeman described and others have described, which is all well known, of the illegal operations that cut corners and has given this all a bad reputation, into shifting into a new era or a new type of thing where they are legal, licensed patients. Now, and there are still problems in terms of impact on one's neighbors and so on, and smell being a big one. But still, we're shifting into that. We heard some evidence over the last few days about, why have some patients not bothered to get permitted and so on. And so you've got some of that evidence from Mr. Garris, and then you've got some of the evidence today from Scott Wilkin, the insurance agent, in terms of the 300 experiences that he's had, and from the fire chief from Fort McMurray, Tim Moon, so that all directed towards counterbalancing the evidence from the government. So again, remembering that all this goes into this pot, if you like, maybe a wrong word to use, but into this soup, in order for the Justice Phelan to have to determine, is that satisfactory to limit these constitutional rights, if you've accepted our Section 7 argument. And so the failure, we say, of the government to allow one to continue does put people in this position where their rights are violated. And the evidence, we say, establishes that all of this can be done safely, securely, in terms of mold, fire, electrical, the chemical thing, all of those things. And that the risk is all remedial, and one can deal with it. And so they're not, we say, demonstrably justifiable as reasonable limits in the circumstances. So, that's what he's going to have to look at and grapple with and try to decide. And he will have consideration of all of the evidence, including your evidence, including Danielle Lukiv's evidence. There's all sorts of people
just so our viewers know, there's a lot of people who fall outside the injunction and may not understand that Mr. Conroy and I and the coalition and other people have been working vigorously to try and find out how to get people who fall outside that injunction proper protection and get this fixed. And part of the reason we did reintroduce this into the courts.
So there's a substantial affidavit from you and my assistant Danielle that sets out a number of situations of people who fell between the cracks. Either they were approved under the injunction and then had a fire that was not their fault or anything to do with their marijuana site, and they have a new site to go to, but they can't change. And so there's a lot of people who fell into that, unable to change their site for all kinds of legitimate reasons. And Health Canada has always said, well, they have to resurrect this entire bureaucracy. But, they still have something called the Office of Medicinal Cannabis, and it still does a number of different things.
It verifies their licenses.
And it certainly still mans the database for the police. So you'd think, our argument again is that that shouldn't be too difficult to enable that. And, the people who've had to move because of the letter, or the November 13th letter that's the subject of the privacy suit, one of the impacts of that have been neighbors who are still stuck on the stigma of it all, or are fearful about organized crime because their whole knowledge of marijuana is built into that sort of a thing. So somehow we need to educate and still, make people realize, that especially now with the trend reversing everything in the United States and heading towards legalization, Canada with an opportunity to look at that too with a new election. So we need to, and I've been saying quite often lately, people who are involved have to control smell. Well, they have to understand their neighbors.
I was surprised to learn under testimony from Mr. Garris that they in fact execute, I know their case has stopped that since, but they executed what essentially is a warrantless search, what I stopped in Abbotsford from happening at my house. Basically, they allowed fire officers to go in on the premise of an electrical inspection to target what they call MGOs. This is part two of my question. How do you feel about that whole lumping together? And even then, it's a fractional statistic when you put together clandestine meth labs, illegal grows, and medical marijuana grows. And at the end of the whole argument, there is zero medical marijuana attributed fires?
Well, that's why, we called the witness Tim Moen, who talked about cultural and confirmation bias and those sorts of things. Again, hopefully we'll be able to persuade Justice Fillon that that's really what was going on there, and that it was very selective. Unlike, in contrast, we will argue Scott Wilkin, who simply had, 300 different people come to him to want to be insured randomly. And so those are the things that we're going to be arguing about and trying to convince the judge that he should accept our evidence. So that's why it's important to appreciate where the onuses of proof lie and where they shift and so on, because I don't think it's that easy to just compartmentalize some of these things, and that's the difficult task that he has, is going to be, to see what evidence goes to the manner of which they've affected the rights and which evidence really goes to trying to justify it. And so, again, I think it comes back to the controlled drug and the public safety issue, and hopefully an acceptance of the evidence that we're now much closer to those natural health care product type situations than we ever were. And certainly we'll submit an overwhelming amount of evidence about how it can be done safely and securely and not impact on others. But again, the people involved have to demonstrate that, and demonstrate it on a daily basis to their neighbors. And I'm being told by inspectors and others that call me that smell is the biggest attractor. They get complaints about smell, so they have to send their inspection team out to check it out. And you'd think that most medical patients would want to maintain privacy, so it's in their interest to try and not do that.
That's true.
But most importantly, we want people in the communities to understand that this can be done without stinking out the neighborhood, without impacting other people's enjoyment of their property. We have to respect other people's enjoyment of their property. Some people aren't doing that, and they're giving cannabis a bad name by doing that. We want people to come on side and realize that it's time to put an end to prosecuting people and to take it out of the Controlled Drugs and Substances Act. This case is not that argument. The Supreme Court of Canada and Malma Levine has said that they can criminalize it. It's a political issue. It's up to the government. So hopefully, though, we will be able to show enough people in Canada that have the right and the power to vote that it's important to get out and vote in order to prevent a continuation of the criminalization of this product, this plant, and that will make the whole medical situation even much more easier to regulate and hopefully provide a good, viable exemption. We won't need an exemption anymore, of course, if the Controlled Drugs and Substances Act, if it's removed from Schedule 2.
Do you see a future, because this is what I see as a future, personally, just from my own outside observation, of the MMPR being party to any legalization platform as a supplier to Canada?
My personal opinion is that creating this whole licensed producer regime with all of the things that are required, I mean, some of them I think are a bit over the top, but that's what they probably require for other pharmaceuticals and so on, and certainly natural healthcare product production. But again, you eliminate the controlled drugs and substances aspect of it, you eliminate a huge cost in terms of security and everything. So hopefully, and naturally, they would become, you would think, the commercial suppliers of cannabis. And just as we submit that the good model, the best model when we're arguing politics is, hey, let them be the growers if they have to meet all of these requirements in terms of selling to the public, but let them retail it and so on through the dispensaries and the compassion clubs in terms of medical, where people can come and see it and do all the things that they can in those places that they can't do under the existing model. And you could have wholly owned dispensaries, for that matter, by the LPs. And that would enable, they'll see that the market isn't going to cause the heavens to fall in or any of this sort of stuff. And hopefully they will see that that also is the appropriate model for recreational. There'll still presumably be a distinction made between recreational and medical. In some U.S. states, I understand it's a pretty fine line. In other U.S. states, they've kept it quite separate. So It's evolving, and we'll see, you know, what the regulations.
Based on you and I, like, we've had many discussions over the past couple of years. Based on our information and the books we've read, can we at least agree that it would be preventative medicine at the very least, based on the fact that humans have CB1 and CB2 receptor cells?
Certainly, for a large number of people. I was watching a video that I recommend people have a look at called "Prescribed Grass." Which has been out, I think, for a few years, and it basically tells the Israeli story, and I hope the court will allow me to play it tomorrow. But Ralph Mechoulam, who is really deserves and does get huge credit for having determined the existence of the endocannabinoid system and THC and so on, he's interviewed, and he makes the very interesting point that, you know, people say, oh, you take some marijuana, you're likely to forget. And he says, you know, sometimes it's good to forget. All the patients who suffer from PTSD, that's what it's about, helping them to forget. So you need to understand that medicine, you know, works both ways. It's not just something that you think may be detrimental, can also be positive in a medical context. And so people have to open their minds and open their eyes.
That's where the education thing comes in, right. where I think that the sooner we all get on the same page, the sooner we can stop that recreational medical divide and kind of get people together to understand that at the very least you're potentially staying off cancer or Parkinson's or working on a knee injury from high school. You just don't even know it, you know, even though you're using it in the recreational context.
And that's a major criticism that we have of Health Canada's position is, you know, they, and we think it was good that they created the expert advisory committee for the doctors to educate the doctors and put lots of, you know, the science and everything together so that they could help doctors overcome this inherent apparent bias towards it. And so that was very good, but as we tried to bring out in the cross-examination and so on, you know, why didn't they do that for patients and growers to show them how to do it without smell, to show them how to take the appropriate precautions? You know, they didn't look at any of the equipment, they said. They didn't bother to really do anything, and they said, well, that wasn't their mandate. But I don't think there's anything in the regs that said they had to set it up for the doctors either. It surely was just, would have been good common sense in order to try and minimize the negative impacts that were being complained of at a certain period in time.
Even the fractional minimal impacts that they were able to demonstrate, it was still the government's own formulary of 13 years.
Well, I think that's an important point because, as you said earlier, you've got all these places in the U.S. where their plant numbers are limited. 15 is I think the maximum in a number of places, and I think there's variations on that depending upon sizes and so on. And so you have Mr. Colasanti's evidence that you can produce as much cannabis from 5 or 6 plants, I think it was, as 600, provided you have the space and so on to do it. So there are various variables and so on. So they came up with a formula, Health Canada, that allowed people with large dosages in particular to grow huge numbers of plants. And, you know, my own, again, opinion is that that was one of the problems of the whole model. And they could have amended that. They could have said, if you're in a residence, you know, and again, we'll argue these things as they're going too far by taking it away when they could have simply legislated so that if it's in a residence, you know, just like the tobacco one is 15 kilograms if you grow it on the property, you know, maybe they want to do less than that for cannabis because of smell or whatever, but they could do that. And they could also authorize the provinces or local governments to do various things, because we know that the impetus has come from local governments, starting with the illegal operations, to have these inspection teams and so on that the witnesses talked about. And so it shows that that can be done in order to correct and make sure that things are safe. And so, you know, those are arguments that we will make to try and persuade the court that all of this can be done safely and securely without impact on others. And there should be education and regulation. It's not a free-for-all. And in order to try and do it without taking away the ability of the patient, if they're able to grow for themselves or have a caregiver do it for them if they can't, so that they can access medicine not only that's more affordable to them, because I think everybody agrees if you grow your own, especially if you're able to put it outdoors for a period of time to cut down the electrical costs, is going to be, obviously the licensed producers can't compete with that, with all of the rules and regulations they have to meet. My understanding is they're generally supportive too, because they obviously want people who can afford their product and not people who can't, unless the Israeli system is put in, which I understand you pay no more than $100 a month, or some other system where
there's a provincial formulary covering part of the medical.
Well, I think it's legislated. It used to be free, and we'll find out tomorrow for sure. But from my reading, that's the situation in Israel.
Okay.
And in the Netherlands, we'll hear this week a slightly different situation. And on its face, compared to us, it seems reasonable. You can grow 5 plants. They don't enforce you growing 5 plants. Or you can go to a dispensary, or you can qualify under the medical and then get some sort of insurance. We've had patients contact us who've gone to court because the government supply from Bedrocan doesn't work for them, and so the government's actually paying them to produce for themselves. But they are people on social assistance and so on. So again, it's the whole affordability thing. But there is more to it than that. There is the desire of people, understandably, who want to control what's in their product and know exactly what they put in, particularly people who have extreme sensibilities. Mr. Allard talked about this a bit in his evidence, as well as the therapeutic aspects. How it obviously, for not everybody, but a number of people, whether it's gardening out in your gardens, which lots of people like to do, this tending their plants and having control over their plants and knowing what goes into them and what doesn't go into them and being able to harvest them and so on, and know that it's going to be their medicine later on. We heard some evidence about how therapeutic that is for people and part of their treatment.
I think Mr. Allard did a fabulous job on the stand. I think he also got into strain efficacies and strain specifics, and it's something the government doesn't even address. First of all, they hold that there's no medical value for marijuana, even though they have a marijuana for medical purposes, program.
Well, it's all stuck on this business of it's not an approved drug. And, they say there's not enough safety and efficacy. Well,
then why put the doctors as gatekeepers to a drug that's not medical?
Yeah, I could have spent a lot more time on that, but it's not really the issue in the case. But I spent a little bit of time cross-examining Ms. Ritschot about all of that. And I, spent a lot of time cross-examining witnesses on this issue in the old Caine case. But the amount of information that's out there about cannabis is overwhelming compared to most other plants and things, including studies, including double-blind placebo-based studies. I could send people a list of a huge number that's obtainable through Paul Armentano, the research director for NORML in the U.S. And there are a lot of studies with bigger cohorts than are done with most other drugs. So, the story that there's just not enough clinical this and that. The recent book by Roger Pertwee, the handbook that he edited, shows a lot of up-to-date things. Robert Clark's book, the American Herbal Pharmacopoeia, in which significant people from Canada and the U.S., Mahmoud El-Soli, others, have contributed to this, and it shows what you can do and what you can't do. So we know an awful lot about the safety. We know there's no lethal dose ratio. So, and that's right in the government's materials for doctors, which is an exhibit in the proceedings. So if there's, it's perfectly understandable if doctors are prescribing opiates or other things that people might hoard and sell on the black market because there's a market for them. That sort of thing, but that's not what's going on here. Or people may overdose on them because they're an addictive or an opiate-based type drug. That's not the problem here. So there surely is far less concern about dosage and so on.
Well, toxicity and addiction, even I think, is questionable at best. There are some people that are going to be addicted to even caffeine.
It depends what you define addiction to be, and if if the definition in the supervised injection site case was one that everybody agreed to, including the government, and it includes pretty serious behavior afterwards when you're in withdrawals of trying to get more of the drug. Yeah. And we do see that in opiate-based addictions where the person is totally out of control. I don't think we see that with cannabis. At least I haven't seen any case studies or anything to suggest that. Certainly people become dependent upon it and want to do it all the time. And my understanding is the irony is that if you do it all the time, you don't really get that much out of it other than a medical patient who is doing it to get rid of the pain, not to get high, to get rid of the pain.
We face resistance and tolerance like any other medication. Like if you were put on opiates, you over a period of time you get resistance and tolerance. Yeah. And I'm speaking from personal, 20 years experience, as a medical user, that I don't really get. I work all day medicated. And people would know that unless I told them, and it's because it helps me. But I don't have to take Stemitol for nausea, Restorol for sleep, etc.
Well, there was the case of the young man in Saskatchewan not long ago who was allowed for 2 years to do stuff at his school, and was doing it privately, as I understand it. And then they said no, he couldn't do it anymore. And as he pointed out, the kid next to him was on Ritalin, and that made him able to participate in school given his condition. And just the same way, it was the cannabis that enabled this person to be out of pain for enough to be able to concentrate and learn and go through his studies. So, the bias, the stigma, the historical stuff that's there is absolutely amazing how big it still remains for many people. But, they got to understand that this helps people to do things, and they don't necessarily get any higher than the person who's on oxycodone or on Ritalin or whatever it might be.
On the Joe,
it helps them do it.
On the Joe Croft show, that was my argument. Joe Croft said to me, "Well, what is it about cannabis that your position?" I guess my main position was, I said, look at how many drivers are driving drunk or drugged, on these pills right now on the street. We don't pull all the cars off the road. We police those drug or drunk drivers.
That's right.
And we shouldn't just throw all the gardens off the
road. And that's an important point, the drugged driving issue, because the law in Canada is that you should not drive while your ability to do so is impaired by alcohol or a drug. There are other laws that deal with alcohol, about how many milliliters of alcohol in your blood and so on, the machine and so on. That doesn't apply to other drugs. The impaired driving law is what applies to drugs. So the normal way to test whether somebody's ability to drive is impaired by alcohol or a drug is to have them step out of the vehicle and do roadside tests to see if they have their balance, to see if they're able to speak, to see if they can follow your finger and touch their nose, all those sorts of things. And police have been doing that forever. And a good thing would be to videotape it so that nobody can question what happened at the scene. You have less trials, less work for lawyers. Yeah. People might like that. So, you determine whether the person's ability to drive. We know that with cannabis, the non-fatty or the non-active metabolites will stay in your fatty deposits for months and would show up on a number of these tests that they've come up with. Sure, they maybe have devices now that can show that you've consumed it, but that doesn't mean that your ability to drive is impaired.
Tests, for our viewers, will these tests stand up to constitutional scrutiny in your legal opinion?
Well, we have to wait and see exactly what they come up with and not be able to understand, exactly what they do. If all they do is say, yes, you've consumed marijuana, then it doesn't establish that your ability to drive is impaired. They need more than that, we will argue. So, people need to understand you shouldn't, especially if you're an occasional user, you shouldn't smoke or consume marijuana and then get behind the wheel of a vehicle or an airplane or operate complex machinery, because you will be affected by it, especially in the first period of time, especially if you're smoking it in rapid onset.
And if you get prescribed opium, don't get in a car and drive either, because the same thing will happen.
Exactly.
So Tylenol 3s, etc.
You need to, again, be concerned about impact on others. You need to always say, I don't want to cause harm to others, just as you don't want people to cause harm to you. And so you need to think about that. But the evidence also, as I understand it, is many medical patients, as I say, don't get high at all. They're doing it so constantly that they're in a steady state, And you could do the roadside tests, and they may be way over. I think what's in Washington State is 5 nanograms, way over, and their ability to drive is not impaired. So you have to take that into account in a fair and just system, in my submission, to look at the reality. And the impaired law, the way it is now, is I think, totally satisfactory. But as I say, you might add the videotape. They have them in their cars, mostly, so on. Why not? It'll save a lot of argument later on as to whether the person truly was ability was impacted in what way.
Absolutely.
So, I think that's an important thing for people to remember. It's another one of these things. Don't do something that's going to negatively impact. Now, the evidence, from what I understand in the U.S., after Colorado and so on, for a while we were hearing that there were more problems, but we've also been hearing that there aren't, that there have been less problems, that certainly prescription drug abuse by young people is way, way down. And I heard, and again, I don't know how accurate some of these media stories are, that the drunk driving or drug driving isn't a big problem, that it has, not manifested the way that they expect it to be. So, very interesting experiments going on in Washington State and Colorado, quite different. And in these other states, I think Washington, D.C., it's no commercial at all. It's all to be homegrown or something. So there's all the different models. It's really quite fascinating.
This has been a great I want to jump into a little bit of the history, and for your fans out there, you've become a rock star for medical patients in Canada. Patients across this country are just chanting your name and thankful for all of the hours and commitment and time that you put into this.
Well, let me add, there's also Tanya Grace, who's up tomorrow, who's been a great help, and she was a great help at the injunction. There's Kirk Tusaw. He was around for the first 2 weeks and was a great help and did great work as well. We've got Bibas Vaze, also helping, did the cross-examination of Officer Holmquist, and young Matthew Jackson, who did the cross-examination on Langara. So a good group of people, and Danielle back at the office, and others, who've, I think, really helped us to be able to present a good case to the judge, to try and cover all the bases possible that we could. And hopefully we'll persuade at the end of the day. But it's important. It's not just me. I've got a lot of people helping me.
Let's roll this back to 2012. I contacted you in fall of 2012 and said, Mr. Conroy, is there a way that we can challenge this particular legislation? And we reviewed that. We grew on February, I'm not sure what date, in February 2013, you wrote a letter at my discretion to Health Canada warning them, we are going to take you to court. We are going to seek an injunction, and that's what we did in February. And then later, after 3,000 victim impact statements, we selected our 4 plaintiffs. And all this time later, here we are. And for the people out there that really want to know, how did all this play out? How is all that going on? Well, that's pretty much how it had played out.
Yeah, I mean, we had to look at all those victim impact statements and try to, we had a huge number of very interesting stories from so many people, but we had to also take into account that this whole case was going to be done on a donations type of funding basis. So we thought, well, we better limit our plaintiffs to people from British Columbia because the case is going to be in British Columbia. That was the only reason for doing that. There are lots of great supportive patients and so on right across the country. It would have been great to have been able to, call everybody we wanted to. But again, it's a constitutional challenge. And people often mix up the class action, which is the privacy suit for seeking damages for invasion of privacy, as opposed to a constitutional challenge, which is we could have had one patient as the patient, but we felt that we had to have somebody growing in their basement, the outbuilding in the country, with people just helping each other, and then the classic spouse caregiver situations to illustrate that, because we are saying grow yourself and caregiver. And they're focusing on in residence, and we're saying, well, it's not just in residence, it's all sorts of other places. So, in terms of the ability to grow. Some of that
confusion comes from the fact that I also filed the Branch McMaster privacy case that's due to be certified in March, and is a baseline $40 million lawsuit for breaching our privacy, and we believe that we're very confident it will be certified in March, and usually Canada will settle, is my understanding.
No, really?
In most cases. But however, as we know, they've been appealing and fighting us every step of the way.
My experience is constitutional challenges, and we're usually there for a long time. They don't usually.
That leads me right into my next question. Now, first off, do we have any questions from the audience? Any questions from the audience? Sorry, John, I'm just going to see if there's anybody that has something to ask.
Okay.
But for the interim injunction, while he scans over this here, for the injunction, now what happens here? Hypothetically, we're looking forward. Just hypothetically, we finish this. Two questions. First off, do you think Justice Phelan will likely wait till after the SCC decision to call his shot?
Well, I mean, we sought an adjournment on that basis, and Justice Manson declined to grant it. But I think our legal team, I think, is in agreement, and will make a submission to Judge Phelan that won't surprise him. That we'll see how Smith goes on March 20th. There'll be a group of us there.
I'll be there. We'll we got a question from the audience. Let's go ahead and take this in. Go ahead, shoot. Question from the audience?
The question is, can the government appeal this decision?
Can the government appeal this
decision?
decision?
Well, we don't have a decision yet, but if we do have a decision and it's against us, we would have a right of appeal, and if it's against their position, they will have a right of appeal. So the importance, of course, as that we were just getting to, is what happens to the injunction. And so people need to understand that the injunction is pending further order of the court. And so we will ask, obviously, Justice Phelan, he's not going to legislate. He's not going to say, here's the solution and come up with the legislation. That's for Parliament.
Yeah, the courts can't legislate. They regulate the law.
Courts, and this is an issue that came up in Smith and will be dealt with probably to some extent in the Supreme Court of Canada. In Smith, the lower court, the trial court, struck the word dried from the regulations. And this, so people, at least in British Columbia, were able to use other than dried. And the Court of Appeal said that was legislating, and said what you do is you strike it down as unconstitutional, you toss the ball to the government to fix it up, and you give them a period of time to do so, and gave them up to a year. And as I understand it, the exemption, because of that, there isn't an exemption, as there was in Parker, for example. Parker got an individual exemption pending the change in the law.
In S56, right?
That's right.
Right.
Or I think he got a court ordered first, and then it became a Section 56.
Yeah.
But here, so it's, I'm still don't really understand how that happened, how you win in BC Supreme Court and you win in the Court of Appeal, but you end up back to the way it was before the court and pending hearing in the Supreme Court of Canada.
No, I'm sure that for our viewer that question leads to, will this go to the federal appeals bench or will this go straight to the SCC?
No, I mean there is probably provision for what they call a per saltum appeal, which goes over one appeal court, but I doubt it. Usually the Federal Court of Appeal would be the next level. And the Supreme Court of Canada wants to hear from, different levels of the court rather than be the first ones to have to decide it.
So how many years?
Smith, you see, we say that Smith's very important because surely the Supreme Court of Canada, for the first time, will hear a medical marijuana case. They didn't grant leave in Parker or Murnaugh. And so we say that they will have to deal with the law with respect to Section 7 and the Parker case in order to get to the issue of whether or not limiting to dried marijuana is too restrictive or not under the Charter. That's a Section 7 and a Section 1 issue.
So it's a test case in essence.
Again, there's a problem. We just, the court will hear the arguments in March. We don't know when they'll come down with a decision. Often it can take up to a year. Justice Phelan will get final oral arguments on April 30th and May 1st. And then it's up to him when he makes his decision. And so we'll have had March, April, May, a couple of months. Maybe we'll get some signals from the court. I don't know, in the Supreme Court. But they've moved it along pretty quickly, the Smith case. So the feeling is they're trying to sort of fast track it. And if that could be relied upon, I would think Justice Phelan would want to hear what that court has to say before making his decision, because otherwise, if his decision is different, that will lead to a whole series of appeals. Where if, on the other hand, if the Supreme Court of Canada has spoken and he's guided by that decision, that could settle the matter for one side or the other, depending upon what they say. So, it's really hard to predict, but yes, to make a long answer to the question, there can be an appeal. And so the question will be, if he makes a decision that is favorable to the plaintiffs, then we will certainly seek to have the effect of that decision continue pending any appeals. So that there'll be at least something like a continued injunction. But hopefully,
in layman's terms, does that mean that the injunction, because I know for myself and for many of our viewers, this is what it comes down to, is will that injunction stand, or what happens after Justice Phelan says, yay, hypothetically,
the injunction is an interlocutory or interim injunction pending trial. So it stays there until further order of the court. So it depends upon what Justice Phelan rules. If he rules that there's no Section 7 violation, that's going to be the end of the matter. The MMPR will be what it is, subject to us appealing and trying to persuade him or the Court of Appeal that there should be a continued interlocutory order pending that appeal. If he rules in our favor, in the plaintiff's favor, then I would expect that in his order he will set out basically what is to happen, anticipating an appeal, and certainly what is to happen, hopefully, with respect to being able to change your production sites, and the issue of the 150-gram limit in relation to the MMAR more than the MMPR, and the issue of extracts, which is the very issue the Supreme Court of Canada is going to grapple with in Smith. So, we will probably seek to persuade him to await the Smith decision before he gives a decision. And I would expect the terms of this injunction will continue until he makes a decision. The more difficult question is whether there's any ability to do something
about the address
before he makes a decision.
That's what I was just going to ask.
So we have filed an appeal from Justice. Well, I guess we've got to file it before the 20th. We had filed, and they said because we thought the Christmas period didn't count, and they said no, you're out of time, and so we sought an extension of time. It was only 6 days or something, and they granted that to us just recently. So we now have to refile that notice of appeal and get back in front of the Court of Appeal on the issue of now what Justice Manson has said, that he didn't intend to cover Beamish and Hebert. And so we need to have the Court of Appeal pass on that, because, as we argued, he found irreparable harm, serious question, that most of the tests for it, but then decided not to give them a remedy because of limiting the intrusion into the legislative sphere. And of course, we will argue that really Beamish and Hebert are particularly the poorest plaintiff, certainly in Tanya Beamish, and has been, very negatively impacted. They are classically in the Parker type situation, we say.
Well, nobody should have to choose between their liberty and their medicine. That's for sure. So, are there any other questions from the audience?
Comes from Evil Dave. How long could the Smith decision take?
Well, it's up to the Supreme Court of Canada. They, there's 9 judges, and they consider all of the arguments, and so it can take as long as they need. I mean, in Malma, Levine, and Caine, I think it took a year. But again, the sense is they have rushed things up a bit in order to get everything in and be heard fairly quickly. So our sense is that we'll see how the the arguments go, and then we'll guess as to whether they'll make it sooner rather than later. Our hope, obviously, but there's no set time. It doesn't say the court has to make a decision in 60 days or anything like that.
Okay. Any others?
Bradley Hunt, will there be room for address changes between the appeals, or will we have to wait until everything is finalized at the end of the appeal?
At the moment, I'm afraid you can't change your production site license, whether you fell through the cracks of the injunction or it happened after the injunction.
I think the question was more in the if we win, and if again we're going to hypothetical, if we win and if the Crown appeals, you know, in the injunction, they're concerned about whether they'll be able to change their address.
Well, as I said a moment ago, I mean, we're appealing that issue, and hopefully the Court of Appeal will decide it at some point in time, maybe before Justice Phelan. It may be that Justice Phelan says something about that after argument. It's certainly an issue that goes as to what happens in the interim pending decisions from either him or the Court of Appeal, and what happens after that depending upon what the decisions are. And, you know, will the decision in Smith be illuminating to all concerned? So there's a lot of ifs out there, and I can't give you definitive answers. But, you know, remember, Justice Manson granted the injunction, which covered a lot of people and enabled us to move ahead in the circumstances. Sure, we're disappointed about what happened in terms of those that weren't covered. It's caused a lot of problems for a lot of people. We've tried to do something about it. Unfortunately, it hasn't been successful so far. We hope that we will be successful in ultimately enabling, you know, if Justice Manson, if Justice Phelan rules that plaintiffs, people who are medically approved, can continue to produce for themselves, then I would expect the government may try to seek a stay on that. And that will give us, I think, another opportunity to then say, well, there should be no stay, and the injunction should go on, including an ability to change your site pending the hearing of the appeal. So,
excellent. You
know, there'll be a number of areas where hopefully you can rest assured that any opportunity we get to be able to make that submission, we'll make it.
And to be fair, so our viewers understand this, that, you know, Mr. Manson didn't get a chance to see this evidence because the appeals court threw it out, and where Justice Phelan has had a chance to see this evidence and will take longer to weigh in this. And this is, of course, an ongoing battle. My question, I guess, would be, there's 270 cases that were stayed pending the outcome of Allard. So again, a hypothesis.
Maybe more. I saw a figure that was higher.
So, a hypothesis, once again, in the position that we win and Justice Phelan issues his decision, will those 270 cases immediately go forward if there's an appeal issued?
Well, I think they're stayed pending the decision in Allard, if I recall the terms of it correctly. And so it will depend a lot, again, on what the decision is. And obviously, if the decision is favorable, it would presumably apply to all of them that fall within the same parameters. Whether there'll have to be hearings or not is an interesting question. I don't know. I mean, Justice Phelan made that order, and so there's got to be a file for each one of those cases in the federal court. And so it really will depend upon his order. Of course, if his order is, no, we're wrong, and he rules against, then nothing changes subject to appeals. But I would expect that if that happens, they will remain stayed pending the Allard appeal, and is the likelihood.
So they'll remain stayed while we're under appeal. So so in again, the hypothesis of a victory, this could, how many years before all these appeals would stop if the Crown keeps going the way they have been? I mean, they've been fighting us every teeth and nail.
Well, we've got Kirk arguing Garber as well, which is a separate case going up through the BC courts. So we'll see what happens there. There's another possibility of things going on there. But I'm afraid it's so. I mean, there's always possibilities of some tinkering and some changes along the way. But basically, the process has to run its course and be done through this procedure. whether they will grant you more of these sorts of things. It's
patients out there can understand.
to try and estimate how long it will go on.
When would somebody who now unfortunately has to fall under this MMPR scheme, when would they potentially be able to grow a plant again?
Well, our hope is that if we succeed at trial, that they will be able to do that pending any appeals and stuff, that they won't have to wait until it's all over.
Yeah.
You know, if they have to wait until it's all over, I think 5 years, well, you know, again, the way they were moving Smith up, my hope would be is that we can move these cases pretty quickly as well. But I would say if a reasonable timetable, or a usual timetable, I should say, is we're probably talking 4 to 5 years.
4 to 5 years.
Yeah.
Wow.
I think.
Any questions from the audience on that one? 4 to 5 years?
Freddie and many other viewers
Little
want to
bit
know
louder.
if we'll win the government start giving out new growers' rights to patients looking to grow. If we win, will the government have to start giving out new growers' rights to new patients looking to grow?
Well, that's the part of the object of the case, is to require the government to put back or put into the MMPR, the new regulations, what was in the old regulations, not all of the old regulations, use for oneself, and a more limited right than what the MMAR said for DGs or designated growers, a caregiver right, so that the patient who wants to control their own medicine and maybe be involved in it to some extent, but is, because of their illness or injuries, is unable to do so, can have a caregiver who may be another licensed patient, like Mr. Alexander in the case of Mr. Davey, who is helping in a collective garden to do things. So we hope that the court will accept our submissions, that should be put back in the MMAR, or into the MMPR, as it was in the MMAR, and that further, it shouldn't be limited to dried marijuana only, and again, that 150 gram limit shouldn't be there. And we've also in our pleadings included that if a person is a producer, that they should also still be able to grow outdoor, at least a part of the time.
Excellent. Any other questions? No more questions? Well, I guess we'll close it out here, John, and just kind of, what would you have to say? The coalition itself, Cannabis Rights Coalition, is now at 105,000 that we've been able to come up with. We're fundraising hard. As you see, a lot of people showed up on the first day of court. You know, Mr. Emery and his wife have been out to support us, and Dana has stepped out. There's been a really large national collective coming in behind this case. What would you have to say that are out there that are working hard to fund this case?
I say you guys have done a fantastic job. We would not have been able to do what we've done up to now without the great efforts and work that the community has done. I mean, the coalition, the you know, other people who are just interested and supportive of the whole thing. I mean, I think I don't know if it's happened in other cases where you have such a collection of individuals, many of whom are on disability pensions, contributing when they can, you know, many of them quite frequently, and it's really been very impressive how the community has come together in order to do this and to bring us all together into a situation where we're, you know, I think we've been able to present a good case, and hopefully it'll be one that persuades Justice Phelan of what we're arguing. And hopefully we will have a situation at the end of the day where the grassroots contributed when they could in order to take a constitutional challenge forward and have it heard by the courts in order to determine their rights without violence, without all kinds of things that we hear and read about in the news from other countries. You know, we're able to do it.
But we are organized now.
So, you know, we're exercising our constitutional rights in order to be heard by the independent courts on whether or not, what the remedy should be in the circumstances. And as I've said before, we're all can be proud of Canada as a first world constitutional democracy.
Well, Mr. John W. Conroy QC, thank you again on behalf of all the medical patients in Canada
you.
and all the work that you do for the coalition. We look forward to bringing more to you on the next edition of Cannabis in Canada. Cheers.
Thank you very much.